Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living here in Utah. Today we're continuing this video series about estate planning for different types of families at different times and stages of life. Specifically today about young married couples or even couples cohabiting or couples who are in serious long-term relationships. In 2017, we do have a lot of different types of families, and the law accounts for them in different ways. For married couples, there are certain rights that are attached to that marriage bond, such as first priority for financial management if someone's incapacitated, or healthcare decision making. But if someone's cohabiting or living together or in a long-term relationship without that marriage bond, there are still ways to make sure that that person can make those decisions for you, even though you don't have the benefit of that state contract. And that is through the healthcare directive and power of attorney. So a healthcare directive, it's a do-it-yourself option. We'll place a link below for these healthcare directives and an instructional video on how to fill them out. But you can make sure that whoever you want, whether that's a parent or a trusted friend or a spouse or a long-term partner, whoever that may be, that person is your first choice for making healthcare decisions on your behalf, and you can have a backup decision maker on there as well. And then a power of attorney, very similar, but for financial decision making, so who can manage your finances if you're unable to do so. For young married couples, another concern is often children. They'll often have children before there are even really assets to worry about. So the main concern then is who is going to take care of the child, and not necessarily what's going to happen to assets. And that is usually done through a will. However, if there are no assets to plan for in any way, so no real estate, bank accounts under $10,000, $20,000, then a will isn't necessarily something you'll need, but you will definitely need something nominating a caretaker for your minor children. That, once again, is a standard form that you can fill out, nominating somebody to do that without going through the formal process of having a will done. And we will post a link to that below as well, so that you can fill that out and appoint someone to, or rather nominate someone to take care of your minor children. Finally, if there are assets for a young couple, then you will want to have some kind of will in place, or something to account for distribution of those assets. That can be something that you do yourself, but once we're talking about real estate or bank accounts worth more than $10,000 to $20,000, we really want to consider getting the opinion of an estate planning attorney at that point. And finally, life insurance as well. A lot of young couples may not have assets, but they do have life insurance. So making sure those beneficiary designations are appropriate for your goals. If the goal is to take care of the spouse first and then any children second, that's great, but be aware that there are some problems with leaving life insurance directly to a minor child, and there are ways around that, and we will link the video where we've explained that below as well, so that you can watch that. Thanks for watching. If you have any questions, feel free to reach out to us at any time.